why are you in jail?
That's a good question. I've been asking that, and no one's told me really why.
You've been asking why you're in jail. You don't know why you're in jail?
No, because I didn't want to get attorney involved and have a big payment of paying an attorney, but I guess I should at first. I wouldn't have been here 4 years. But I guess for whatever I did with my wife, she said I choked her or something. What I did, let me explain this exactly what I did.
What charges?
Yep. Was Judge, I was out on the street.
Wait, I'm going to stop you right there.
Okay.
Because you're being recorded and you're under oath. So if you say something about your pending criminal case, the violation of probation, the district attorney's office can use that to show the judge that you have admitted something that may violate your probation. So don't talk about what that pending case is. Okay? You understand that?
Yes, sir.
All right, step down, have a seat. Ms. Brady Wilkerson, this complaint that you filed does not contain a prayer or request for alimony. It only requests a property division, and I don't have any proof in the record regarding the value of the house to determine whether awarding it all to her would be an equitable division or not. So I'm going to grant you the permission to amend your complaint to add a prayer for alimony if that's what you wish to do. I'll reserve the granting of the divorce to allow you to do that, and we'll reset it for the 27th of this month. And at that point in time, I need to have some evidence regarding the value of the house and whether there was any debt, and also the evidence regarding that was justified any sort of alimony award. Mr. Doris, I'm going to have another hearing. I'm going to have another hearing in your case. That hearing is going to be designed for me to determine the value of this house and where it ought to be, how it ought to be divided. If she should get it all as alimony, or if it should be divided and give you a portion of it. But I have to have a hearing where that is an issue. And I'm sorry I can't conclude it all today, but clearly there's evidence that would award her a divorce. But in that granting of that divorce decree, you need to provide that I've granted you 30 days to file an amendment. Well, let me give you 10 days to file your amended complaint if you're seeking alimony. So. All right, that's the judgment of the court. We'll see you all again on the 27th.
I don't even know that one.
You're going to get yourself in trouble if you keep talking to them. All right, call the next case. In re the estate of David Phillips. All right, anyone who's going to testify, raise your right hand and let's place you under oath.
Yes.
Go ahead.
Your Honor, we're here today to open the estate of David Phillips, which is the brother of the petitioner. We provided to the court the best will we had. It
doesn't sound
pretty
good.
embarrassing.
This is the best will you have?
Yes. It appears to have all that it needs to have, but it's just very ugly. It's a draft. I don't know why it's not the final, but other than that, other than it being ugly, it appears to be valid. We need to have this submitted because there's some specific bequests to otherwise people who would otherwise not be heirs.
So you're wanting to admit the will that was sworn before witnesses on the 17th day of October of 2025, is that correct?
Yes.
And this is a photocopy of a draft,
Yes.
but you're saying you don't know why it was never made.
He was working on the will, but this illness progressed so fast that he didn't finish it. Or that's as far as he got.
Well, the will makes you the sole beneficiary, whether there were other, if I saw it correctly, I may not have. Is there any?
Mr.
I
Phillips,
meant,
he would be the only heir at law, but the will gives some substantial property to others.
But you have waivers of the others that are mentioned.
We
right?
do.
All right. As far as you know, this is the only will of your father.
yes, sir.
All right. We'll admit that one into probate.
Your Honor,
You have an order prepared.
I don't, but I will send it.
Thank you. I'll grant your request and put it as soon as your lawyer gets your order in, I'll sign it. Okay.
Thank you, Your Honor.
Thank you. Good morning.
From the Nashville Bar. This is our petition to admit a will for the sole purpose of establishing muniment of title to a piece of real property. Angela Eddy is, we represent Cynthia Blanky, the sister of Angela Eddy, who's the decedent, and she was under conservatorship. And she has since died, and we are just trying to transfer a title of her property.
Right. No opposition to your petition. I will grant your request.
I believe there's already an order in the
There
file.
is an order in the file.
Thank you, Your Honor. Good morning, Your Honor. This is my claim to the exception to the claim of Northcrest Medical Center. Your Honor, the only thing I received as far as their claim was this. There's no bills, no invoices, no.
Anyone here from Northcrest Medical Center to assert their claim? No one here. Your exception is granted.
Thank you, Your Honor. Thank you. Your Honor, that's our petition to appoint a successor personal representative of the estate. This is a very old estate that's been open for more than 10 years. We were here about a month ago on the clerk's motion to dismiss the case or close the estate. We have since filed a resignation from the personal representative who was previously a employee of the Community Foundation, and this petition to appoint Molly Lacker, who is the owner of Sunny Care Services. I don't think that we have, yes, I have her oath here.
Yes, go ahead.
That's the one thing we were lacking to get in the file for today's hearing, Your Honor, is the personal representative oath signed by Ms. Locker. there's just a couple of things that need to be done to finalize this so that we can close it. And the previous personal representative is living in Iowa, and made it impossible to get that accomplished without appointing someone else.
I'm going to have this oath file, marked file, but do you have an order granting your request as a substitute?
If there's not one in the file, I'll submit one today, Your Honor.
Okay. I will grant your request. Obviously, we need to try to conclude it. So if you'll submit an order, okay?
Thank you. There's
Thank
not one in the file.
I
No,
didn't see
okay.
one, but the clerk may find one. If she does, I'll sign it.
Okay. Thank you, Your Honor.
Point out at the very outset that I've got the right docket number on here, but the incorrect style.
Okay.
This is the case that started out with a conservatorship for Miss Page. You were the judge when this was before the court, and we had a conservatorship. She's deceased. Now we have an estate, and we've got this conservatorship, which is not closed and won't be closed until the court orders it closed. I've tried to get I've called Mr. Temple. I've sent him a copy of the motion. I've told him that the conservatorship needs to be closed, and so we can make an accounting and get whatever assets are into the estate account. And that's what this motion's for. So.
Well, obviously, that would be the requirement of the law, since there's been a death. Party passed away in November 6th of 2025. That concluded the conservatorship by operation of law. So clearly the obligation is now to transfer that to the estate. I will grant your request to order that the assets, that a final accounting be made and that any remaining assets be transferred to an estate. Has an estate been opened?
What, is there a time limit, Judge, we can put on that for him? Because,
Time limit?
you know, a date by which he should do this.
I would think shouldn't really be a problem to do it within the next 30 days. So
Okay, that's
all
good.
it is to finalize the conservatorship, file a final accounting within 30 days.
Okay,
and,
thank you, Judge.
Show that those assets should be transferred.
I'll get an order up here. I'm sorry. Thank you.
All right, 30 days from the entry of the order. Put
Yes,
that in there.
yes, thank you.
Good morning, Your Honor. This is a motion for default judgment on a petition to modify a parenting plan.
And you're here on a motion for default.
Mr. Bearden is incarcerated, Judge. He's here in Cheatham County. I think you called his name earlier, Kenneth Mitchell, sorry, Kenneth Mitchell Bearden.
Let me take just a minute to look through the file.
Yes, sir.
They were divorced in July of last year.
That's correct, Your Honor.
So he was served on the 28th day of April.
Yes, Your Honor. And there's a restraining order that was granted by Judge Lockhart Mash as well.
Did I understand you to say he was in jail somewhere?
He's here. He's here in Cheatham County Jail, Judge.
Technically, we're supposed to, by Supreme Court rules, at least if he is in custody, we're supposed to at least let him have an opportunity to participate if he chooses to do so. Why is he in jail? Is it because of?
Judge, he has a domestic assault against his own mother. I think he has a gun charge where he pulled a gun on one of his friends. There's also been some threats to Miss Bearden where he spit on her during one of the exchanges. And And then I think that's all set to be heard. You know what the date is?
September.
It's in September. He's got that pending court date on those charges.
So today, what your petition is asking is simply to suspend his visitation.
We have a parenting plan for your consideration, Judge. Basically, what it's going to do is give mom, 100% of the visitation until he's released and completed an inpatient rehab. And then once he's done that, he'll get a Saturday supervised until he can do that for 6 months and show that he can stay clean. He's had a significant drug problem. And then so once he's clean, that would go unsupervised, but then it would be on him to file a petition to modify it further.
All right, well, let's put your client under oath and let her testify to those facts. If you'll raise your right hand, please.
Yes.
All right, ma'am, can you state your name for the court, please?
Hannah Bearden,
All right, Ms. Bearden, you were divorced when?
July 1st, 2025.
Okay. 25? Yep.
Yeah.
Last year.
Yep.
And then as part of that divorce, there was a parenting plan.
Yes.
And since that parenting plan was entered, there's been a material change in circumstance, right?
Yes.
All right. Can you tell the court a little bit about what has changed since then?
Sure. My ex-husband has a severe drug issue and problem, and we've dealt with it for a decade or more, and I dealt with it in our marriage. And I divorced him due to multiple drug issues. I've had restraining orders and orders of protection throughout the marriage. So since July, in the short period of time, July to November, when he was incarcerated, he pulled a gun on his friend, evaded arrest, had a domestic assault against his mother, and continued to threaten me while incarcerated. And that's what,
And Ms. Bearden, since you were divorced, he's had a relapse of his drug problems.
correct.
And so for a period there, he was clean, and then he's had a significant
Correct.
relapse and led to all these criminal problems.
Correct.
And you've had issues during your exchange of
Yeah.
children. He
Yeah.
spit on you during one of the exchanges.
Showed me.
He shoved you. He sent you threats via text messages.
Yes.
He sent you messages that were incoherent.
Yes.
And even after being incarcerated, he was sending you messages from jail.
Yes.
And then we had to get a restraining order from that.
Yes.
And that was granted.
Yes.
And then you've got this parenting plan here for your children.
Yes.
You have 2 girls.
Yes.
And you feel that this parenting plan is in their best interest?
I do.
And that this parenting plan would keep them safe until he can get his drug problem under control?
I do.
Around this, my proof.
You have a proposed parenting plan? That
I do, Judge. I have a proposed parenting plan, and I have a default order if you.
Oh,
And then, Your Honor, if you'd like a final order, I can add that after.
Morning, Your Honor.
good morning.
Andy Pulliam on behalf of the plaintiffs, Urban Capital LLC and MP2 LLC.
Good morning, Your Honor. I'm Michael Bly. I'm the Cheatham County Attorney representing Cheatham County.
And Your Honor, I'm Kevin Baltz. I represent Century Communities of Tennessee LLC. We're the defendants.
Well, since I have not had an opportunity to read through your file, you're going to tell me what this is about. I know what the motion is on the docket is to schedule an evidentiary hearing and briefing schedule, and a motion on the motion for temporary injunction.
Your Honor, that's all that we have before the court today is requesting an evidentiary hearing before the court related to the motion for temporary injunction. We were wondering if that's possible to be done on the 27th in the afternoon.
How long do you think that hearing will take?
Probably no more than 4 hours is my estimate. I've only got 4 witnesses, and 3 of those witnesses will be very brief.
Well, 27th is already a fairly full day. That's when I was smiling, because when you say 4 hours in the afternoon, I have a feeling it would be longer than that. So your estimation is that it would be 4 hours?
Your Honor, I will let opposing
Let's have
counsel
the other-
speak to their.
He
to
says
their-
4 hours. What do you say?
I only have 4 witnesses. 1 will be no more than an hour. The other 3 are fairly short. So I'm 2 hours at max would.
You know, when I was standing in your shoes, I would appear in front of Judge Robert Birch, and he would ask me how long something would take, and I'd give him what I thought was an honest answer. He'd say, turn to the clerk and say, double it. So I'm just, and I have found that unfortunately to be true, as much as I regret it. So I'm not fussing at you. I'm just trying to get an honest idea. It's unlikely I can give you the afternoon of the 27th for a 4-hour hearing, because we've got a fairly full day with some contested matters. So it's is probably looking at a different day to have that heard.
That's fine, Your Honor. The only reason I mentioned that is because I knew that the court was
Yeah,
here on that day.
I did mention that earlier. What do you, are you available on the 16th of this month? That's just next Thursday, a week from now.
I am, Your Honor, yes.
I'll be out of town, Your Honor.
You're out of town?
Yes, yes, Your Honor. The latter part of next week, Wednesday through Friday.
I'm also unavailable that afternoon.
Well, let me take a break and make some calls. I'm starting in August. My first 2 weeks of August, I'm in Stewart County, and usually there's not a very heavy docket. I may be able to shoehorn you in on one of those days if I can find out. You'll give me a few minutes to make some calls. Okay? Anything we haven't addressed?
No, sir.
All right. We'll see you all on the 22nd.
Thank you, Your Honor.
Thank you, Your Honor.
I'll draft an order.
That's fine. Be careful in Alabama's. My experiences in Alabama are usually at UT games, and that's not a very good thing. So.
I've done that before. I'm sure back to school today. Thank you.
All right. The next case is Gregory Bryce Baker versus Sheena Marie Raven Wingate. And that is Miss Wilkerson and Miss Shanley. Shanley, can you hear everything okay?
Yes, Your Honor. Can you hear me as well?
Can we turn the volume up on the TV a little bit? There's a remote for the TV separately that you might be able to use. Let me see. We were turning the volume up. You're coming across on a big screen TV here in the courtroom, and we are turning that up for you to be able to be heard more clearly. This is a motion to compel the respondent to allow the father to have unimpeded FaceTime calls with a minor child. Is that what I understand?
Yes, Your Honor.
All right. Ms. Wilkerson, you represent the father, is that correct?
That's correct, Your Honor.
You want to tell me what's going on and why you need this motion to be heard?
Yes, Your Honor. So over the last few months, there have been a lot of issues with the phone calls. The parties just cannot seem to get together on when these phone calls should be taking place. I've talked to my client, and he has suggested Tuesdays and Thursdays at 7 p.m. That would alleviate a lot of the issues as far as what time these phone calls should be made. That allows him time to get home from work. The child's almost 10 years old. The other ongoing issue is that the mother is insisting that her FaceTime, he's always done video calls with his child since the child was 2 years old. Child's almost 10. Insisting that her video on her phone isn't working, but it has no issues when the child's at his house and the child calls the mother. They FaceTime. So I don't know what the issue is there. It would seem to me that if the FaceTime works when it's at dad's house, then it would work when it's at mom's house. The other issue is that the phone calls just simply aren't unimpeded. Mom is right there the whole time. She doesn't let the child go to his room or another room in the house to be talking to the father. In the father's house, the father gives the mother the courtesy of allowing the child to go into the bedroom where there isn't a camera and the child is able to talk to the mother unimpeded. And he's just not offered the same courtesy at the mother's house. So these are the issues that have been going on. I'm just asking for an order that the phone calls happen Tuesdays and Thursdays at 7 o'clock, and that they be video chats, and that the child is somewhere free from distractions, so that the father can actually have meaningful conversation with the child.
Ms. Shanley, do you have any response to that?
Yes, Your Honor. And just for the court, my client is also present. Just so Your Honor is aware, it looks as though father is asking for unimpeded FaceTime calls. Tennessee law doesn't require that he be provided FaceTime calls. He is granted 2 actual calls per Tennessee statute, and FaceTime calls are allowed if available, Your Honor, is what the statute permits. And mother has been very clear with father that she was having issues with her camera, with her phone. That information was provided to father. That information was also provided to opposing counsel. And she has since then been able to fix her phone. Father has been able to exercise FaceTime calls with the minor child. Petitioner also alleges that he's only had 4 phone calls within the last month as of when this was filed. Your Honor, my client goes above and beyond to ensure that father has the opportunity to call the child. Father makes a decision either not to or is unavailable to. We do not have any objection to a set schedule being put in place for FaceTime or for calls in general. Your Honor, we would be asking that the motion to compel be denied just for the simple fact that father is not entitled to FaceTime calls. And even if that were the case, mother has made him very well aware that she was having issues. Her phone has since been fixed. She is typically in the vicinity during those calls. Mother does not interject herself into those calls. If the minor child does sort of revert to her at any point during those calls, she essentially states, please talk to your father about this. So she is not impeding on any sort of phone calls. She's not interjecting herself into any sort of phone calls. And for those reasons, Your Honor, we would ask that the motion be denied, but we would ask that a temporary plan until something more formal is put in place, a temporary schedule be put in place as to a time period for which the father is supposed to call to speak with the child, not requiring mother to call the father. And Your Honor, we would also be requesting that the parties use a parenting app. I think there are some issues with the parties being able to properly communicate. So we would just ask within that order as well, for a schedule that the parties be ordered to use a parenting app as well.
Does either side wish to put on proof about this?
Your Honor, no, because I think we're really kind of saying the same
Doesn't sound like to
thing.
me that you're either one. Let me just say this. The statute may not say that FaceTime calls are part of what is provided for the mandatory telephone call, but where available, this court favors FaceTime calls because it's the next best thing to actually being face to face with your child is to have the FaceTime. So it seems to me reasonable that so long as the technological problems have been resolved, that the father would be allowed to have 2 FaceTime calls during the week with his child. I think the proposal that has been made is we set Tuesdays and Thursdays at 7 p.m. Any objection to that, Ms. Shanley?
Your Honor, I think we had requested to do between 5:30 and 7:30. So I think 7 p.m. should work for mother and the child's schedule. Yeah, between
Did you say
5:30
your
and
client
7.
is here?
Yes, Your Honor, my client is present in the courtroom as well. We had originally requested 5:30 to 7 p.m., Your Honor.
The problem with 5:30 to 7:30 p.m. is that that's a pretty big window that is not definite enough that would allow it. I am going to order that Mr. Baker will be responsible for initiating the call. That way he can set the call, and we just need to set a time that's convenient. Shirley, your client is here. Do you have any problems with the 7 o'clock Tuesdays and Thursdays? All right. So she's here and she just agreed that 7 o'clock on Tuesdays and Thursdays would be fine if Mr. Baker is the initiating party. So now you got an 11-year-old, right?
10.
10. Okay. All right. Then it seems to me that they're old enough to be able to talk to their dad without you having to be, monitoring it and so forth. So let's let them have privacy when they talk to Mr. Baker. That doesn't mean you can't ever go in the room. It just means that you're not hovering over the shoulder and that sort of thing. I'm not saying you do that. I'm just simply saying I'm putting an order down so that both sides feel like they've been treated correctly and fairly. We're going to let him set the time, and he's now responsible for placing the call. So you have to be available for 7 o'clock. 7:15 rolls around, he hasn't called, then he's waived that call. You understand that? Mr. Baker, I'm giving you that much time. So if you're going to call, you got to call. Now, I would like to think that the two of you could communicate via text message without any issues, but Ms. Shanley was suggesting a parenting app.
My client doesn't oppose it.
Pardon?
My client doesn't oppose it.
And let's get them involved and go ahead. Yeah, come on up a little closer. Miss Wilkerson won't bite you as far as I know, so.
And suggested to him that the co-parenting app to communicate with, and I have seen him everything that I have on it. We are able to set schedules on it. I can put in for doctor's appointments on it, and he is able to see it. Just both of us have to be responsible and pay for our subscription to it.
Well, I think that's a reasonable thing. So I am going to order that you initiate this parenting app. What it does is it essentially insulates the two of you from having, you wouldn't believe how many of these cases I see where there are text messages that are snarky back and forth with each other, even over things that should be discussed without that kind of problem. So we'll initiate the use of that parenting app. Your lawyer can send the information to Ms. Wilkerson, and she can set that up with her client. But I am going to order that the parenting app be employed. And that way, both of you can communicate without any kind of issues and hopefully start to better co-parent your child. So we've got 7 o'clock Tuesdays and Thursdays. He has until 7:15 to initiate that call. And then if he doesn't call you by 7:15, you're free to go about your business. Now, as a practical matter, 7:16 rolls around and he calls. I'm going to ask you to, I'm not ordering you, but I'm just saying, the common sense would say, give him an opportunity if something's come up and he's running late. But by law, you're going to only be required to wait 15 minutes if he hasn't started at 7. So, okay. Anything else we need to address?
Do they have a preferred parenting app that they want to use?
She
Yes.
has already got that information. It's my understanding that have you given that to Ms. Shanley? Do you have the information on the parenting app?
I do, and I believe, Your Honor, the information has been sent directly to father as well. So I would request, for the sake of the order, that a time frame be put in place for father to get the actually
I would say
download the app.
15 days would be sufficient. Let's get it initiated at least by July 31st. That will give you plenty of time.
Which app is it?
Starting, the parenting app needs to be implemented by July 31st. Make sure you and your lawyer provide that to Ms. Wilkerson, even if.
Signed it at 9/14 of 2023, and then it was thereafter adopted by the court. Your Honor will recall I filed a petition to modify the parenting plan and had a ex parte restraining order issued due to the fact that Mr. Brian Keith Phelps had been arrested, charged, and ultimately convicted of driving under the influence when their party's eldest child was in the car with him. The testimony from the hearing that we held on November 5th on the extension of the order of protection, Mr. Phelps testified
that he and his son had gone to a local swimming hole. He had consumed significant alcoholic beverages. He drove with the child, was pulled over by a Robertson County law enforcement officer charged with driving under the influence. And he pled guilty to that, was placed on 11/29 after 48 hours, suspended license, and ordered to only drive a vehicle with an interlock device on it. And he testified to that, and that is sworn testimony that has happened before this court that Your Honor heard. Your Honor heard the testimony, and an order was entered at that point in time that you did not extend the ex parte order that prohibited him having any contact with the children. But you made the following findings: that the petition counsel, I had called the respondent, Mr. Phelps, to the stand, and he testified that he agreed that the permanent parenting plan stated that he was not to consume alcoholic beverages to excess during his residential time with the party's minor children. He testified further that although his consumption of alcohol had been at the time of the party's divorce, such action was the basis, his actions, because he had drank at the time of the divorce, that he understood that that prohibition was put in the parenting plan. That he knew he could continue to drink, but he just could not drink to excess in the presence of the children. He had testified that he had gone to the swimming hole, had drank 8 to 9 beers while operating his truck with the child. He confirmed that he was pulled over. He had a 0.19 alcohol level in his system, which was almost over 2 times the limit. And Your Honor entered the following order: that Mr. Phelps would that the parenting plan would remain in effect, and he would continue to have residential time with his children as set forth in the order, but that Mr. Phelps was specifically restrained, enjoined, and prohibited from consuming, possessing, or in any way subjecting the party's minor children to any type of alcohol during his residential time, including but not limited to his own personal use, or allowing any other individuals, including his current paramour, from consuming, possessing, or in any way subjecting the children to any type of alcohol. It's further ordered, judged, and decreed that there will be no alcoholic beverages at the home where the respondent is exercising his residential time. And your order entered that on December 10th after the hearing on November 5th. I had forwarded that was sent. Your Honor held that for 10 days prior to you doing it. At this point in time, Your Honor, I filed a petition for criminal contempt alleging that he testified under oath that he violated the original terms and conditions of the parenting plan by consuming 8 to 9 beers, having a 0.19 alcohol level, and driving with his minor child, and that was a violation of the original parenting plan. And we allege that was a valid court order, and that he is in criminal contempt at that point in time. I further alleged about the allegations, or the fact that he had pled guilty and that he was not to drive by the child. On November 23rd, the respondent appeared at the home to pick up the children. He was driving a vehicle without an interlock device installed. The daughter took photographs of that and forwarded those to her mother. And in fact, at the time that he picked the children up on November 23rd of 2025, there was a beverage in the cup holder that she photographed showing a twisted tea. It was in the cup holder within the vehicles, and the daughter, who I think just turned 11 or will be turning 11, photographed that. On December 5th, we alleged that he again picked the minor children up for his scheduled visitation, again driving a Nissan vehicle that did not have an interlock device on it. My client questioned him about why he was driving and why he didn't have an interlock device. And he stated that he had paperwork and suggested that the petitioner take him back to court. That interchange is recorded. Further, on December 7th, the daughter sent 2 photographs of Michelob Ultra that were in the respondent's laundry room. And that is in a violation of the court's order where there would be no alcohol in the home, and that is in violation of the court order. And since that time, there have been at least 7 other occasions that he has violated the terms and conditions by having alcohol in the presence of the children, including this past weekend, where he went to a party where other adults were drinking with the minor children. So we're here seeking a criminal contempt for the ones that we cited in that petition, and we're asking that he be jailed for 10 days for each violation that the court finds.
All right. You wish to respond, Mr. Porter?
Yes, Your Honor, if I may. Your Honor, I was the recipient of the first petition for criminal contempt. And then somewhat perplexed is when I received the second petition, Your Honor, that was amended. Specifically, there are no stated allegations as to which we are seeking to have 10 days for the father to be incarcerated. We're asking for each violation to have 10-day incarceration. But specifically, Your Honor, under perfect pleading here, we do not have a situation in which I'm certain as to which order we're saying that my client has violated. Certainly, we're not here today on contempt matters that are orders that are outside of this court's purview. This court did, however, make an order stating that, yes, albeit everything that you heard from Ms. Roberts be true from my client. I believe you actually heard it from my client's mouth the last time, Your Honor. Albeit that, none of that is pertaining to what we are here today, where my client is on trial for criminal contempt for violation of the court order that states that he is not to have alcohol in the presence of his children or consume it, Your Honor. When it comes to the idea of not being able to control the world, if you will, Your Honor, a party, a restaurant, I don't know at what point in time your order would, Your Honor, extend to the idea that my client is to remove his children from alcohol at all times. But I would also state that that is not here, again, under this contempt petition today. I would tell you, Your Honor, that what we have is nothing in this pleading pertaining to the fact that the children have told the mother that they have seen father consuming alcohol. Nothing in this petition pertaining to the fact that they have said that father smells like alcohol, that a paramour smells like alcohol, that anyone in the house smells like alcohol, that anyone appears to be under the influence of alcohol, Your Honor. What counsel comes today with is a couple of photographs. Your Honor, they're not in the photographs that I have, the photocopies. I can't make them out. They're in black and white. I don't know where they're at, Your Honor. But we have what appears to be alcoholic beverages somewhere. So I would tell the court today that mother is attempting to incarcerate father for some photographs that were supposedly taken in 2025, I believe, maybe one in 2026. But Your Honor, they were taken by the party's minor child. Surely that leaves me to confusion as to why it is that the minor child feels the need to be photographing things at father's house. If that is indeed what she's doing, I believe it would draw into question some of the issues that we might be having here, where the children are being brought into this case way more than they should be, Your Honor. They are here if the court is so inclined to discuss with them. But it's our position that my client has not violated this court's order in any way. He's not consumed alcohol around these children. He is very well aware of how he was admonished the last time that he was here. He is very penalty for his actions. And Your Honor, I do not believe that he should be found guilty of these contempts.
Robert, you may call your first witness.
Your Honor, the question being, do you want the minor child? Shaylin will be my first witness.
This is the minor child.
Yes, Your Honor, she's the one that photographed.
And are you wanting to have him testify in chambers?
I mean, it would be up to the defendant.
You have a right to have her testify here in open court, or you can have her testify back in chambers, but.
Your Honor, we're fine with chambers.
All right. Then we'll take her up inside the jury room, so.
Yes, Your Honor, both children are back there.
They were both back there?
Yeah, I had asked, that they just be placed back there before we started the hearing, and it's actually the father's time with the children, and so he brought them, and I just asked, and they politely agreed. They show that it was entered on January 4th of 2024. Does that comply with your recollection?
Yes.
You got a copy of the parenting plan. Your Honor, may I approach?
You may.
Never. Y'all understand this process?
Yes, yes,
You. Practice. Correct?
yes.
Okay, I'm hearing.
The,
You could read under section J for students.
the father shall not consume alcohol to excess during his parenting time. Mr. Phelps had a drinking problem during our marriage.
Okay. And to your knowledge, did he voluntarily enter into this agreement?
Yes.
Has he ever raised an issue that he was forced, threatened, or otherwise
No.
did not agree with the terms of this agreement?
No.
Have y'all followed the terms of the residential schedule?
Yes.
Have y'all made some deviations when you needed it?
Yes.
And, do you know, was there any reason why that you would be aware that Mr. Phelps was not capable of understanding the plain language of this order?
No.
Did you discover at some point in time that during the residential time that he was exercising with y'all's children, an event transpired that resulted in Mr. Brian Keith Phelps being arrested? Did you discover sometime that he had been arrested? And did you have a conversation with him about that? How did you find out?
A friend called me and told me that they saw his mugshot.
Okay. And you did some investigating
Yes.
and found out that he had been charged with driving under the influence and reckless endangerment because your oldest child was in the car. Is that correct?
Yes.
Did you reach out to him or did he reach out to you and say, hey, this?
He did not reach out to me. I sent him a message that was in a group text with my mom and his mom asking if we could chat about what transpired, and I sent a picture of his mugshot.
And what happened with that?
No response on the group chat.
Okay. And then we had filed a petition with this court seeking a modification alleging those facts had occurred. Is that correct?
Yes.
And we came to court in November of 2025, and you were present at the time. Is that right?
Yes.
And were you present during Mr. Brian Keith Phelps' testimony?
Yes.
Did you hear him testify?
Yes.
And again, we filed a petition for contempt, and we set forth in that petition for contempt certain allegations. And did you read that petition? And were those allegations true?
Yes.
Do you recall whether or not that Mr. Brian Keith Phelps admitted under oath that he consumed 8 to 9 alcoholic beverages while he was at a local swimming hole with your son, Bentley?
Yes.
Did he testify that he blew a .19 when he was arrested and subjected to a breathalyzer test, or excuse me, had a blood test?
Yes.
At that point in time, was he questioned, and did he admit that he knew there was a prohibition about him drinking to excess with the children?
Yes.
Are you familiar with whether or not he was found guilty pursuant to a plea of guilty?
Yes, I was present at his court hearing.
So you did where court was that in?
Bronx.
Okay. And you were present and heard him admit that he was driving at his plea hearing as well as in this courtroom, sitting from the same place you were sitting right now.
Yes.
Is that correct? We came to court after that. We came to court on that November 5th, and were you aware of what terms and conditions the court set down?
Yes.
And you have the order from the November hearing? Your Honor, may I approach?
You may.
It is ordered, adjudged, and decreed that the respondent, Brian Keith Phelps, shall remain as set forth in the permanent parenting plan, but he is specifically restrained, enjoined, and prohibited from consuming,
possessing, or in any way subjecting the party's minor children to any type of alcohol during his residential time, including but not limited to his own personal use, or allowing any other individual, including his current paramour, from consuming, possessing, or in any way subjecting the minor children to any type of alcohol. It is ordered, adjudged, and decreed that there will be no alcohol beverages at the home where the respondent is exercising his parenting time.
With y'all's children?
Yes, he rents a home on 1070 James Circle.
And at some point in time, your children at the time were 11 and 13 when this happened. They've just recently turned.
Yes, so they
well,
would have been 10 and 13.
10 and 13, excuse me. Did you communicate with your children that certain restrictions had been put down by the court?
Yes, after the day that we came home from the court, where I made them aware of what the judge had ordered.
Okay, and why did you do that?
So they knew the truth.
Okay. In what manner did you tell them?
Told them that me and their father had went to court and the judge ordered that there would be no alcohol consumed or in the house or around them during his parenting time.
Were you under the understanding that your son was in the car when he drove drunk?
I didn't find out until 2 days after Mr. Phelps
But when
was
you found
arrested.
out he was arrested, you did know that
Yes,
Bentley was in the car. Were you aware that your daughter came to the scene?
after the fact, yes.
Okay. Do you know whether or not they left before he was arrested and done stuff, or did they watch it?
I was notified that the officer did Mr. Phelps a favor by letting the children leave before she arrested him.
So have you seen the effect that this arrest has had on your children, particularly your son Bentley?
Yes.
Can you describe what that is, what you've seen?
Roberts, I hate to interrupt, but this is just a petition for contempt, right?
Right, and again, this is, the reason I'm getting into this, Your Honor, is simply because you witnessed the child's testimony.
I did.
And so just in the measure of truth and veracity, if there's a question as to what happened with the children, the reason that I'm getting into that is simply because you have to judge the truthfulness and veracity of the witnesses. And that's why I was having this, not from a custody standpoint.
Right.
So,
For that reason, I'll allow it.
I feel like Bentley has a hard time when it comes to his father. He doesn't want to get his father in trouble. And so he tries to avoid conflict and shuts down.
okay. And the same question with Shaylin. Again, you weren't present when the children's testifying. But again, and you prefaced it, you don't feel like Bentley wants to get his father in trouble. So it begs the question, do you think Shaylin wants to get her father in trouble?
I don't think that she wants to get him in trouble, but she knows that he's not supposed to be doing things, and she's a little bit more vocal on you shouldn't be doing that versus Bentley just bats an eye and doesn't want to be involved because therefore he can't say anything.
Okay. But have they been truthful to you about things that have gone on in the house over there?
Yes.
And in that vein, did you ever instruct your daughter to do anything while she was at her father's house?
No.
But has she done some things while she's at her father's house about giving you information?
Yes. She's asked several questions about being at a restaurant and then talking about ordering drinks. She's texted me and asked me if they could do that. If they're at someone's house and someone is drinking, she just in conversation exploits that information. It's not like I'm asking 21 questions to get the information out of her.
Is she a rule follower?
Yes.
And has she, over the course of several months since we were in court back in November, routinely sent you photographs of things that have transpired or she has witnessed in the home,
Yes,
and the home being Mr. Phelps's home.
yes.
May I have the exhibit?
Yes. Yes. From Shaylin. Yes. Yes. From Shaylin.
May I approach him?
You may.
Some other things that include names.
Yes.
Starting on the front page, this appears to be a screenshot of what is the date for this?
Saturday, March 14th of 2026.
There's no photograph of shit. The thing that come over from here is a photograph of what appears to be a shopping bag with a twisted tea out of that. Did you receive this from your daughter?
Yes.
And is there a date stamp on it?
Monday, February 2nd of 2026.
So is that when you see? She sent it to you?
Yes.
And was she at her home too?
Yes.
What is this picture? And that is in the exhibit from the photograph. Can you identify, did you receive this picture?
Yes.
And who did you receive?
Shaylin.
And what is the date stamp on it?
Saturday, January 31st of 2026.
And did you receive that from your daughter?
Yes.
And did you, was that the day that you received it?
Yes.
And she had a knowledge of that?
Yes.
And again, what does this appear to be?
I'm a case of Michelob Ultra in the refrigerator.
And so it appears that somebody's opening the door and taking a picture of it. Right?
Yes.
Did you receive this photograph in a text message?
Yes.
And who did you receive?
Shaylin.
And you know when you received it, was there a date stamp?
Thursday, January 1st of 2026.
And again, there's a, you see.
Yes. Yes.
And again, was this a photograph of him writing the paper?
Yes.
And did you receive this from you?
Yes.
Date you received it?
Saturday, December 27th of 2025.
And again, is this the truck that you used in the garage?
No.
And it showed that this is kind of built in with your. Were you able to see that?
Yes.
You have a video that was.
Yeah. Yes.
Again, it was, there's no picture. Right up.
Yeah.
Same is there is a photograph, really dark, that was. Is this a photograph that you received the attention?
Yes.
What is the date that it was?
Sunday, November 23rd, 2025.
And then is it the big twisted T and all shown?
Yes.
Okay, what is this?
A twisted tea in a cup holder.
And it was at the same date. Did you get it?
It's Sunday, November 23rd of 2025.
All right, Mark. They've already been marked as exhibits, or those new ones. All right. Mark them as the next exhibit in order collected.
Do you believe each and every one of those photographs and the dates done depict a violation of this court's order,
Yes.
as well as his conviction and his admission of driving
Yes.
intoxicated violates your original parenting plan? Is that correct?
Yes.
You believe that he has the capability of understanding and comprehending? In fact, is there a audio recording, a video recording that you had where he makes statements?
Yes.
And what is that?
I asked him why he was driving a vehicle with not an interlock system, and he said that he had a piece of paper stating that he could do so, and if I had a problem with it, to take him to court.
Okay, and you obliged, is that correct?
Yes.
Do you know whether or not, do you punish your children when they disobey you? And what type of punishment do you impose on your children?
Usually I take things away, PlayStation or a phone, or I don't let them do something.
Okay. Are you aware personally whether or not Mr. Phelps requires the children when they're in his possession and during his residential time that they have to follow certain rules?
Yes.
And if they don't follow the rules at his house, do you believe or understand from your personal knowledge and conversations with him that they're subject to punishment?
I don't have conversations with him about punishment, but the kids have told me that they've been punished for certain things over there.
Okay. So if your house that you have to abide by rules, and at his house, your children have to apply by rules, and there's punishments attached to that, do you believe when you disobey or he disobeys rules that y'all should punishment should attach?
Yes.
Do you think that's a significant example that your children need to learn?
Yes.
Are you concerned for your children's safety if Mr. Phelps does not understand the gravity of the fact that he has to comply with the rules that are set down for him?
Yes.
That's all.
Or you may ask.
Ms. Phelps, or excuse me, I apologize. Ms. Miles, do you attempt to co-parent with Mr. Phelps?
Yes.
Okay. Why was there no attempt to co-parent with Mr. Phelps as it came about with this order and what was to be done in his house? You stated that you took it upon yourself to tell the children what was to be occurring at his home. I would like to know, I think the court would like to know why you didn't see that as an opportunity to co-parent and ensure that the father was aware of that situation.
I'm sorry, I'm blowing my nose. Repeat your question. Yeah, Jeffrey. Sustained, the court will speak for itself.
Why is it, ma'am, that you did not see that it would be a good idea to co-parent, tell the children along with the father so that they were on the same page?
Didn't see that it was necessary to have a conversation with him about that. We don't talk about that with our children together. We don't do anything together. As far as communication, we do communicate. But when it comes to sporting events or anything like that, we separate and there's nothing talked about.
But you would testify that you made your children well aware of what was occurring in court.
To an age appropriate degree, yes.
And you would then also then say that you were receptive of your daughter sending you the photographs, correct?
Yes.
Okay. Is it your testimony that you did not ask her to make these photographs?
No, I did not.
Is it your testimony that you've never inquired upon her to take further photographs?
She has asked me what she should do, if she should take a picture, and I've replied yes. But other than that, I have not given any other authorization or advice to her on what she should do.
And again, in an attempt to co-parent, that did not happen. You did not make a communication with the father, correct?
As far as Shaylin taking pictures and sending them to me?
Yes, ma'am.
No, I did not.
With the alcohol that you say that you see in the photographs that came from Ms. Shaylin, according to your testimony, did you attempt to talk to the father about that?
No, I did not.
You're aware that your daughter has no issue with finding her father in trouble, correct?
What's the question?
You're aware that your daughter has no issue finding her father in trouble. She's pleased to show you these photographs.
It's not that she's pleased. She wants to make sure that he's doing what he's supposed to be doing.
Objection as to the formula. Sustain the objection.
Again, you've not declined the photographs and you've not spoken to the father about the photographs, correct? You are aware that you are to attempt to co-parent with the father, correct?
How am I supposed to co-parent with him regarding that when he is not doing what he's supposed to be doing?
Well, ma'am, I will get to ask the questions from here. You are aware that as part of your parenting plan, we talked about your parenting plan today, so we're going to bring that back up. The first thing in there is an attempt to co-parent. But you're stating today to the court that you've not made any communication with the father concerning this, correct?
Not about the photographs, no.
You also have said that your daughter is a rule follower. But you then testified to her having, at her father's house, been in trouble, I'm assuming for not following his rules.
I don't know what goes on over there other than what they tell me.
Okay, what has she told you she's in trouble for then?
Lots of things.
Could you please enlighten us?
Being disrespectful to Jennifer.
Okay.
Having an attitude, having a smart mouth.
What started as a routine divorce hearing quickly turned into an emotional courtroom moment. The husband, appearing from jail, begged the judge not to end his marriage. He insisted that he still loved his wife, wanted counseling, and hoped they could rebuild their family. He even claimed he had built their home with his own hands and simply wanted to go back home. But the judge made it clear that the court could not force someone to stay in a marriage. The law doesn't allow a judge to order reconciliation when one spouse wants a divorce. As the hearing continued, the husband's testimony became more emotional. He started talking about his criminal case, but the judge immediately interrupted him. The judge warned him, "I'm going to stop you right there." He explained that anything the man said under oath could be used against him in his pending criminal case. It was a serious warning designed to protect the defendant from making his legal situation even worse. The judge also